Hello, all. Welcome back to another session of this interesting course, which is titled Legal Essentials for Human Resource Management. Now, this is the final session of week 2, which also completes 10 total sessions of this course already. Now, if you remember this entire week, we were focusing on the initial part of employment, which includes employment contract. The first session was all about understanding what is work and what are the various types of employment. Now that we have understood that, we are moving on to understanding what is employment contract and how to draft it and what are the key provisions related to employment contracts. Now that we have a fair idea of employment contracts, in the last class we moved into the concept of standing orders. Now, standing orders is a set of rules and regulations which are part of daily functioning of the workplace, to put it in a layman's understanding and to water it down to a very simple form. So last class we looked at what is standing orders, what is the relevance of standing order, if you remember, because a workman who enters into a new work may not be aware of what are his provisions regarding, let's say, applying for the leave, or what are the additional benefits I have, what are my work timings, will I be paid more if I do overtime, and employer, since employer is in a position of power, may be misusing that ignorance. So that is not correct. Hence, we have certain set of rules and regulations, and the Standing Orders Act specifically tells ki you need to have one. So we started off with how to draft it, what are the components of it. But I also told you that it has to be certified by a certifying officer. So in today's session, we will be looking at what are the various procedures related to certifying your standing orders, and what happens if you don't follow the standing orders. And we'll also look at some key provisions of the Standing Orders Act which you should be aware of. So without much delay, let's get into session 10 of this course, which is titled Laws Related to Standing Orders Part 2. And by now, I'm sure you know me well. My name is Dr. Amish Samalopanan, and I'm an assistant professor at Nalsa University of Law. Now, last session we discussed how to draft standing order. Now we have the standing orders which we have drafted. Now let's get it certified. Now certification is given if provisions made for every matter set out in the schedule which may be applicable to the industrial establishment in a fair and reasonable manner. So if you remember our discussions in the last session, I told you that there is model standing orders, or rather in the schedule of this act, there is a model standing order, basic standing order that has been given. And what are the various provisions that should be included, that is also mentioned, which essentially was our last class discussion. Now, if the standing orders you have prepared addresses every matter that is given in the schedule of Standing Orders Act, especially if it is applicable to your industrial establishment, some of the provisions may not be applicable. So all those provisions which are applicable to your industrial establishment, if you have covered it, and the key word is in a fair and reasonable manner. It's not just covering it, but the provisions that is mentioned are defined, explained in a fair and reasonable manner. So certification is given. Now, how does the procedure happens? The certifying officer to which you have submitted these copies required to forward the copy of the standing orders that you have submitted to the certification officer to the trade union of the workmen. Now, what is trade union and all we will discuss in upcoming weeks, where there is an entire week we have dedicated for industrial relations and how to resolve conflict with workers. Then we'll discuss these terms. But I'm sure as a layman understanding, trade union is a group of workers which have come together. So the certifying officer have to forward this copy within 15 days to the trade union of the workman and ask, do you have any objections for it? So if you remember, while drafting the standing orders in the last class, I have told that it is a good practice that you consult with your trade union when you are drafting. The whole logic of that statement was that anyway, within 15 days of the certifying officer getting this, he will forward it to the trade union. So better that you resolve whatever conflict is there with the trade union at the initial state itself. Now the trade union received it. Now what should a trade union do? They should conduct a meeting of the workmen and elect 3 representatives who will read through the standing orders and will approve it or not approve it, or provide any suggestions. So that is done, and the trade union representatives who were elected. I'm really sorry. If there is no trade union, that is when this provision kicks in. So the workmen will elect 3 representatives to whom the copy has been given. So if there is if there is a trade union present there, there's no need for electing one more time. So that trade union would be having the elected representatives already. Now, on the basis of suggestions, make modifications in the standing orders. Suggestions given by the trade union / elected workmen. Now, this certified standing orders, the certifying officer have certified it, along with the order to the employer that this has to be applied at your workplace, has to be sent to the employer, and it has to be given to the trade union of the workmen or the elected representatives. So this certified standing orders has to be given along with an order to the employer, to the trade union, or if there is no trade union present, the elected representative within 7 days. Okay, 7 days of certification. Now look for any suggestions. If there are still suggestions, you need to incorporate it, and then the final standing orders come to stay. No, that would be applied. Now the certifying officer has to complete the entire procedure within 60 days. You'll see that there's a 15 days in which it has to be given to the trade union. The suggestions will come back. It has to be incorporated, an order has to be given within 7 days. Then if there is any suggestion, that has to be incorporated. So it's a long procedure, has to be completed within 60 days. Now if the certifying officer does not complete the process within the 60 days, whatever draft standing order that you have provided, or even if it is for the modification, sometimes this is not a fresh standing order, it's more of a modification that you're giving. Whichever cases, if the certifying officer doesn't complete the process within 60 days, the copy that you have submitted is deemed to be certified. So that's how it works. Now look at certain key provisions of the Standing Orders Act. Now section 6 speaks about appeals, which says that any employer, workman or trade union, so these are the 3 key players at a workplace. So any employer, workman or a trade union who is aggrieved by the order of the certifying officer. Let's say the order came in and any of the party has a complaint. Within 30 days from the date on which the copies of the certified standing orders are sent to the employer or trade union and the workman, an appeal can be made to the appellate authority. So let it be employer, let it be workman, or let it be trade union. They get 30 days to appeal in case they have any objections regarding the newly applied standing orders. Date of operation of standing orders is what section 7 deals with. It says that the certified standing orders, now this is the certified standing orders, will come into operation on the expiry of 30 days from the date on which the certifying officer sends the authenticated copies of the same. So once the employer receives the certified standing orders, the employer has 30 days to apply it at his workplace. Now, once there is a standing order that is applied at a workplace after this process, and you should understand it's a lengthy process which will take around 60 days, and of course involvement of multiple parties. Now this standing order should not be modified until expiry of 6 months. So you have to live with it for 6 months. You might have realized there's a problem, but you didn't appeal for it within 30 days. Or let's say the employer wants to make certain changes, he realized later, you have to wait for 6 months from the date on which the standing orders, or let's say it was a modification, so the last modification came into operation. But this section says that if there is an agreement between employer and workman, or let's say trade union of the workman, they can make certain changes. So that's kind of a given, because it doesn't have to go through the formal route if between employer and employee there's an understanding. Now another important section of this Standing Orders Act is section 9, which says that the text of the certified standing orders is required to be predominantly posted by the employer in English and in a language understood by the majority of the workmen on special boards. So it's not just that you have a standing order, it should be displayed in a clear manner in one, English, and second, in the native language. So let's say it's a factory in Hyderabad and majority of the workers are Telugu speaking workers. So the certifying orders, the standing orders has to be displayed in a special board. It's a legal mandated thing. It's a compliance related thing. So it has to be put on special boards where all the workers can see it. So it has to be either near the entrance through which majority of the workmen enter the industrial establishment, and if there are multiple departments, at the entrance of all the departments where workmen is employed. So the whole idea is that everybody should be aware and everybody should see that these are the standing orders. These are the rules and regulations at the workplace where I am working, so that he is also aware of one, what he need to follow, second, what are his rights relating to leave or salary or overtime, etc. Another important provision in this act is subsistence allowance section 10A, which says that let's say a workman is suspended by the employer pending investigation or inquiry. It often happens at workplaces that a workman or an employee is suspended pending inquiry. Or let's say there is a charge of a misconduct. Could be any sort of a misconduct ranging from aggression, stealing to sexual harassment. So there is a charge of misconduct and he is being suspended pending inquiry. the employer is required to pay the workman subsistence allowance. Now, what is subsistence allowance? So, whatever wage the workman was entitled to immediately preceding the date of suspension, let's say suspension happened in December 2020-25, that month the salary what he have received 50 percentage of the wage. Now, what is wage? Components of wage is another discussion point which we'll discuss in upcoming sessions. But 50 percentage of the wage amount has to be given for the 90 days of the suspension, first 90 days. So the whole idea is that an inquiry has to be completed within 90 days, and either call him, yes, he have done this, so take certain actions, or say that he is not found not guilty, so bring him back into the work. So whatever you're going to do, it's a legal mandate that we'll discuss in the session dedicated for domestic inquiry. So this is what I've been seeing. Labor laws never work in silos. You need to know basically all aspects of its applications in practical sense. So here, let's say we're just talking about subsistence allowance. You should be very clear about what is wage, what are the components of wage, also what are the basic procedures in domestic inquiry. And then we are talking about standing order side. So it's an interplay of minimum 3-4 acts just to deal with this person who is suspended. So the first 90 days you have to pay him say 50 percentage, and if you're not able to complete the disciplinary procedures and proceedings within 90 days, you have to increase the rate to 75 percentage for the remaining period of the suspension. So that's the concept of subsistence allowance in section 10A. Now, what are the powers of the certifying officer as well as appellate authority? So the certifying officer has the powers of a civil court, which means that they can call for evidence, they can administer oath, and they can enforce attendance of the witness, they can call witnesses, they can summon people, which is the power of a civil court, so that all sort of inquiries, discovery of truth, vagera can be done. So that power the certifying officer has. I mean, the correct way to say that he has the power of a civil, he or she has the powers of a civil court. Now, let's say the standing order while coming in, there was certain clerical or arithmetical mistakes or certain accidental slip. Now, according to the act, for the next 6 months, this will remain as the rule and regulation for the workplace, and then they have to submit it back, then in multiple copies, then the certifying officer will send it to the trade unions, they will read it, they will give suggestions, again given back, 30 days given for raising any appeal. But why all this for a small clerical error? So the certifying officer also has the power to make these basic corrections in the certifying officer as required. Another provision is the provision for temporary application of model standing orders, which is section 12A. So for the duration between the time when the act becomes applicable to the industrial establishment and the date on which certified standing orders come into operation in an establishment, by which what I mean is, the act says that there is a mandatory number of workmen or rather worker, as per the newer terminology, required for standing orders to be applicable. And on a fine day, the number of workers crosses that threshold, which means that from this day we are liable, or we should have a standing order. But we also learned that it takes minimum of 90 days. What about those 90 days? Will there be no standing rules and regulations for that 90 days? So section 12A says, at that duration, a model standing order shall be put into place. So I told you in the act, there's a provision which says the model standing orders. So that would be the standing order for that duration. What are the penalties and procedure? Let's say an employer fails to submit draft standing orders or modifies standing orders. What happens to him? He decides that despite meeting those numbers, I don't want a standing order at my place. There would be a fine of 5,000 rupees. And if he continues to do this offense, for per day 200 rupees. So make no mistake, it's not about the money, but often it's all about you being flagged. So the trade union will know, the certifying officer or the labor department will notice you as a defaulter, which will come back to you. So that's the whole purpose. And let's say the employer applied the standing order, but he does things against it. If that's the case, there would be a fine of 100 rupees, and if the offense continues, further a fine up to 25 rupees for every day during the offense continues. So, I mean, to modern day students who read these number figures might feel like it's a very small punishment, but in terms of you being in the radar of the labor department and often in the radar of trade unions as an employer which shows unfair labor practices, that dent is much more bigger than the financial dent most of this penalties and procedures give to a workplace. With that note, let me complete today's session. If you remember what we discussed, we were taking the discussions a notch beyond drafting of standing orders. We are discussing how the entire process of certifying a standing order happens, and what are some of the key provisions, let it be substantial allowance or penalties, all such key provisions we had looked at. By that, we cover this entire week also, which was a discussion on the initial part of employment, starting at drafting of employment contract and the standing orders or the general rules and guidelines of the workplace. Now, with a sound understanding of that, let's move ahead to the next week. In the upcoming week, we will be discussing about what is the wage, how is wage defined, what are the types of wages, what are the components of wages, and above all, what are the obligations of employer in relation to wage. So, with that note, let me conclude today's session. Thank you for your patient listening, and you have a great day ahead. Thank you so much.